Jó napot, jó délutánt kívánok tisztelt hallgatóimnak. Alexin, Zoltán vagyok, és
Good afternoon, all of you. My name is Zoltán Alexin, and I'd like to apologize for delivering my paper in Hungarian, taking into account the interest of the audience. The Hungarian audience, obviously, because they are the target audience for some reason, and also there's going to be English translation, simultaneous interpreting, and the slides are going to be in English. Let me just tell you a couple of words about myself. I graduated from the University of Szeged, University of Science of Szeged, and then I postgraduate PhD degree, word processing, and then I started to focus on data protection, but I've been spending my career mainly as an IT expert. Recently, I participated in research development projects as a data protection expert, and data protection sub-projects and working packages are the sections I'm leading. The future ICT.hu project is in progress. This is going to be completed by December. Two faculties of law from Szeged and Pécs, we are carrying out data protection research. One of the outcomes of these projects is that we have compared the European and Hungarian data protection law and rules and regulations, so the legal and regulatory framework. Now, healthcare data is one specific part thereof, because we consider healthcare data to be the most sensitive private-owned data under privacy. So it's really like using a microscope. So the healthcare data actually magnifies all of the anomalies. So therefore, our experiences therefore are much more affected by that. So this is really heavily under privacy considerations. I have been leading certain cases at court, before courts, civilian courts, and also the court of constitutional courts, like 10 odd cases, which is much more than what the data commissioner and the commissioner of human rights altogether have submitted. And this very clearly indicates the significant emphasized difference between European and Hungarian legal practice. The European Union, including Czechoslovakia, the Czech Republic, Slovakia, and Romania, even in those countries, the approach, the attitude of the legal and regulatory framework and the legal practice, so the implementation, law enforcement implementation is significantly different compared to the Hungarian. Well, Hungarian data protection law says that you can deal with personal data only if someone individually, the person provides the consent, or any law or legal regulation provides so. So this is where the problem lies, because at the end of the day, there is no consent in none of the cases, but there is always a legal obligation. One of the most important outcome of the Constitutional Court cases is that whenever you have a physician's prescription, and if this prescription is for a medication that is not subsidized by the National Healthcare Fund, then your Social Security number should not be on the prescription, because like 2/3 of the drugs are subsidized by the healthcare fund and 1/3 is not. Therefore, in that cases where there is no subsidy, there is no reason to have your data there. In 2009, the Constitutional Court ruled that it was contrary to the Constitution to have your Social Security number on prescriptions when you buy non-subsidized medication. I mentioned the future ITC.hu. I'm one of the sub-leaders of the project. You have a web page. This is being implemented at the University of Szeged. You can go to the internet and check it out. I'm also participating in an international project, and this comprises 26 countries of the European Union. It's a cost project. This is new identification of privacy multimedia content for privacy protection. That is the title of the project. I'm running the data protection sub-project. I'm the Hungarian manager thereof. Now, very briefly about the content of my presentation, my paper. I'm going to talk about some peculiarities in the beginning, and then I try to go into details concerning the underlying causes. The European Union has a data protection regulation or legislation. It is a directive. And obviously directives are such that the member states need to transpose that into their own legislation. That is compatible. National legislation has to be created in line with the directive, the EU directive. Therefore, it is not identical with the directive. It is just, so this is not directly applicable. It is just an adaptation of that. Therefore, there are different legal interpretations, and that may modify and affect the content and the legal practice. Let me also talk about the consequences later on. Then I'm going to give you some case studies, European Court case studies and Hungarian Constitutional Court case studies, and then I'll try to wrap it up in the form of a certain conclusion. It is of essence that in the European Union a new data protection or privacy law is being created, GDPR, General Data Protection Regulation, which is not going to be a directive any longer. It is going to be a directly applicable, that is a regulation which is directly applicable in all the member states. Therefore, in case of Hungary, that would result in a thorough change. This is why Hungary is opposing the adoption of this new legislation as of now, as of yet. Now, what sort of peculiarities or curiosities there are? Let's talk about the data provision, I mean, right to information. So whenever your data is being handled, managed by any authority or any organization, you are supposed to have information about that. You don't have in Hungary, other than the utility companies. Utility companies do give you information that you're handling and managing your data, but for example, healthcare institutions, healthcare service providers, any authorities or any official public administration bodies, they do not inform you about handling and managing your data. You have no right to protest, although this is granted to you in the Hungarian Data Protection Act. But as I said, in Hungary this does not work, because whenever there is a compulsory handling of data ipso jure, by force of the law, then you cannot, then this is always an excuse, and this excuse always applies in Hungary. There are 4 to 5 different cases when the law specifies the right to protest, but as I said, I can use my one hand to count all the cases, all of those cases. Second is that there is an abundance of legislation. There are like 700 pieces of legislation, 300 laws and 400 regulations or decrees. These are all about data protection, and these are all compulsory. Now, this is not the case abroad, because much less in number, much less legislation is enough. And also the abundance of legislation results in the fact that you just get lost in the maze of those pieces of legislation. Therefore, it is always possible to justify the handling or handling of personal data by just combining a wide series of this abundance of laws. Now, whenever you go to court, the court would just check whether there is any obligation, compulsory obligation due to the regulations, and then the judge would just say, well, we're very sorry, but this is prescribed in law, so ipso jure, by the force of law, is going to be granted. Again, consent. The Hungarian healthcare can function in such a way that there is no consent ever, and still your data keeps going on from one place to another. Abroad, this would be impossible. You always have to sign your informed consent document, which is being sent to you electronically or offline or hard copy. In hard copy, in Hungary, this never happens. Now, what is most shocking, and this follows from the above, and follows from the attitude as well, that research on healthcare data, that again is considered to be compulsory data handling. So it is like our data is being used, again, as I said, without our consent and without information provided to us. Healthcare-related or medical database, these are mushrooming lately. There are dozens of medical and healthcare databases which are constantly and permanently being being loaded by data coming from the countryside, coming from different healthcare service providers. There is a beautiful table spreadsheet here. In the law of the European Union, it is well known that there is compulsory data handling. You can see that in the upper line. I mean, those who can see it, because it's too far for me. And then, in the next line, you have data handling that is allowed by law, but it is not compulsory. And then there's the third category, which is the consent-based. So in the EU, you have three different levels: compulsory, allowed, and consent-dependent data handling. Now, this middle one, the allowed, is missing in Hungary. I just wrote 1% is the proportion in Hungary, because in Hungary the data protection law has been modified because of Google Street View. Jóri András, the previous data protection commissioner, issued a position paper. He was right, saying that Google Street View could not operate in Hungary because it cannot be considered as compulsory because there is no such law, and therefore Google Street View should seek the consent of all of the citizens. But then, based on the request of the United States and the US Embassy, a certain amendment has been made to the Act on Data Protection, and therefore especially tailored to Google Street View, a new amendment has been made to the law. Now, this is a pie chart. The pie chart showing you the white part is like 70% of the data handling, is the allowed, which means there are two equal parties, civil law subjects, and the law is not really prescribing anything. So you can, as a citizen, turn to go to court, and the court would assess and adjudicate whether the use of your data was rightful or not, and you also have this, therefore, the right to protest. In Hungary, you don't have that. Going back, as far as data protection is concerned, we have very important rights, like, for example, preliminary consent, right to protest, right to remedy, legal remedy, that is, go to court. And this in Hungary, this in Europe is being used by the law enforcement bodies, and also by the bodies of investigative bodies. These are coercive measures used by these authorities, like secret services, police, and so forth. However, at the allowed data protection, there is a compulsory right to information. Everyone has a right to protest. Now, this is missing in Hungary. This middle part is not there. Therefore, our rights, privacy rights, are infringed. Actually, not only infringed, but they are quasi non-existent. So we have to just cope with and cope with the fact that our data is being used. Now, legal experts do know are aware of this situation. They call this phenomenon the bipolar legislation, and since the middle range is missing, the one I was talking about, so the allowed use of data. Therefore, there is a huge opportunity for abuse. Like, for example, they're asking for your consent when you're not giving consent voluntarily. Like, companies do start out from the fact that how could I handle data if there is no legislation? Therefore, they provide me with a paper to sign. Like, for example, if you go for, you want to have a insurance policy, and you want to actually subscribe for a SIM card or phone or mobile providers, and also in labor law, like, for example, use of GPS in a corporate car, a fleet, a pool car. Now, there as well, your employers are going to ask the consent of the employee so that the GPS track and trace system could be incorporated. Now, the employee would obviously consent to that, provide the consent and sign the paper, otherwise he would be fired or sacked. And this is the legal use or illegal use of the consent. And in some other cases, when they think that data handling is needed, then just new legislation is being passed, so there is an abundance of rules and regulations, in which case they just deprive you from the right to protest and the right to launch a court case, a suit. And the third thing is that every now and then you come across illegal use of data, because sometimes they don't have enough time to enact a new decree or regulation, and therefore the given organization, typically public administration body, would start the activity without the legal background. The recent one was the Health Development Institute. The Ministry of Health launched a tender, and then the winners were selected, but the legal background is not there because that was never enacted, according to our view. And certainly, each and every case when our rights, when we are being deprived from our rights, like there is no information provided, there is no right to protest, this is a grave infringement of our rights. If we want to dig deep down to the foundations, then we could and should mention the European Convention on Human Rights, Article 8 of which is about the protection of privacy, and paragraph 2 says that no one is entitled, the state is entitled to intervene individual privacy. Obviously, there are certain exceptions, like, for example, crime prevention, home defense, epidemic prevention, and other major interests. But this is taxatively specified. Now, Hungary never implemented that. This is not part of the Constitution. The Constitutional Court never dealt with it. I made a motion, an initiative, but the Constitutional Court was not willing to take sides. Apparently, currently, Hungary is just disregarding this piece of legislation. Another important thing is the Charter of Basic Rights in Europe. European Basic Rights Charter. This is one of the chapters of the Lisbon Agreement, and the Lisbon Agreement, the Lisbon Treaty, is just a somewhat simplified version of the Treaty of the European Union. This has been in force since 2000. one, if I'm not mistaken, and this provides, just guarantees the right to privacy and the protection of human, private, of personal data. Now, a free and voluntary consent is required in the European Union for each and every activity of such. Hungary has never realized that. The way this is put in the constitution is that you need, that your consent is needed. Your consent is needed if invasive surgical or medical action is coupled with the medical activity or the research activity. But if there is no invasive part of the medical interaction, then there is no need of consent. And this is something the Constitutional Court actually ruled already. They came up with the institution of the physicians working at companies, so the working at companies. Anyway, the Constitutional Court said that in those cases, the above-mentioned constitutional principle does not apply. The next thing is very important as well, talking about the human right, the privacy directive of the European Union. Since the Charter of Basic Rights of the European Charter of Basic Rights of Human Rights made this compulsory, therefore you can go to the Court of the European Union in Luxembourg, and you can refer to, as a legal basis, you can use the Charter of Human Rights. But the EU is in quite trouble because there's only one legal text that deals with privacy and data protection, and this is the above-mentioned directive. Therefore, and this directive is not compulsory in all of the countries, and this is why the European Union normally goes back to the philosophy, so the principle, the legal principle, which was created with exactly the purpose to be in a position of comparing the different pieces of legislation, and there are rulings, court rulings, saying that the data protection law applies in an equal form in each and every country. Not the whole directive, but of course the given court ruling would just specify which article is taken into account as legal basis. Sometimes they say that paragraph 28 applies to all EU countries equally, and then paragraph 9 applies to all EU countries equally, going further and so forth, as a result of which probably sooner or later the whole legislation will be such. And this is what triggered the idea to have the next piece of legislation such, so that would be directly applicable in all the member states. Again, that is called regulation. This is Article 7 of the directive, and what we can see here is that you have 6 different legal bases allowed by the European Union, as opposed to the 3 that we have in Hungary, because in Hungarian law this is about consent, this is about compulsory ipso iure, so by the force of law, and the third one is because of vital interest. But I think that is also part of the Hungarian data protection law. In the European Union, you have 6 as opposed to the 3 in Hungary. These 3 ones, the missing one, are entering into contractual relations. The second one is data managing of public interest, and the third one that is missing here is that data handling because of rightful interest. Now, this means that data handling is not compulsory; it is just allowed. And the reason that this is within the the legislation is because, like a state authority decides to create a database from the day after, and then someone goes there, then they say that yes, this is proportional, this is in line with the public interest. In that case, you don't need the consent of those affected. So the data of whom is there. So there are two different cases. Either those affected will accept that, or they might go to the court or the data protection institution.
Obviously, the 95% of the people will not go to court, just accept it, but some actually do take action against. They go to court, and they probably actually work for all the others that are the silent majority who don't go to court. And then this issue will be settled in a court procedure. So these cases include the possibility that the affected person will eventually even lose, because if there is a higher interest linked to that, to getting those data, then the individual person will lose out. Section F concerns data processing for the purposes of legitimate interests. This is normally used in contracts. In this case, there is no consent is needed, but the person must be informed. Here, once again, we do not. This does not require the creation of new laws. It's just the realization of business interests. Optimization of a company's operations is acceptable as a legitimate cause. Once again, a table for this. On top, you see obligatory by law. The central part contains the four permitted categories. We have seen this table before. I tried to inform the European community about the lack of legal basis, and to make them actually proceed against Hungary for infringement, but they have not actually finished processing my motion, but they answered that they cannot start such proceedings against Hungary because there is a preamble 34 of the directive which states that certain very important social interests, member countries can utilize mandatory data management, and the case I raised was of a healthcare nature, and the red parts show here that the data protection directive states that healthcare data can or may be managed in the case of vital interests like public health or social aspects, or health insurance, or research, or government statistics. So they pointed the finger at these red parts, and they said that their hearts are actually bleeding, but that they would lose the case at the European Court of Justice. There were some other cases that were adjudicated by the ECG. It has not handled many data protection issues. In 2003, they had a case concerning the Österreichische Rundfunk (ORF). The radio's employees, as well as other public servants and public administrators, were obliged by law to report these to a state organization, to report these employees to the state organization. Obviously, employees did not like the idea and they tried to resist, which resulted in a court case where the court called on the Austrian legislative system to decide on whether this data management was actually based on public interest. Please, they said to the Austrian legislation, please deliberate this. It is only allowed if it is a public out of public interest, and please also adjudicate whether this is commensurate. This reporting of employees with the importance of the issue. The second case already affects us because the Spanish telecom started a case because in their case data were sent abroad while this was not allowed in the country except if the persons gave their consent. So the companies actually went to court against the Spanish state because the state did not allow them to handle data based on interests, and the companies actually won the case. So the European Court stated that Section F means that any data manager must be enabled to handle, to manage data. So the data protection law, paragraph 7, the data protection law applies everywhere in the same manner. Then there is another case, once again, about data management based on appreciable right. A German company passed on data in its possession to third parties. This was Telefunken. When Telefunken at the time collected the data, it requested the consent of the people to their data being offered a searchable database of their data at the site, but then Telefunken handed over these data to third-party companies, other companies, who were allowed by German law to create a nationwide directory. Employees, the subscribers, went to court against this, that they have once again not been asked their consent, and the subscribers in this case lost the case because the data usage has remained unchanged. In both cases, a directory was built. They have actually consented to a directory being built of that data. At the time, Telefunken's interest was to pass on these data, and Germany has passed a law concerning this and authorized these two companies by law to create such a nationwide service with a nationwide directory, and the European Court said that this was a legal or appreciable grounds for creating the database. This may be of interest to us. This is the dismissal of András Jóri, human rights ombudsman, who was actually kicked out in mid-term. And his position actually ceased to exist. They did the same for a number of other authorities where they wanted where the government wanted its own people to be in position. So, well, in most cases, European Court of Justice did not have anything to say. But in the case of Andasjori, the data protection ombudsman, was too much for them. So the European Commission started a suit against Hungary and also won it. So the European Court of Justice actually passed the decision that Hungary contravened the data protection clauses prescribed in the European directive. Obviously, they have not restored him to his position, but actually paid him. They paid him his salary that would have been due for the remaining 2 years of his office. And another case is this phone data retention directive. When the terrorists destroyed the Twin Towers in the US, a couple of years later, the European Union brought or passed a law mandatory for all countries mandating the retention of phone data for up to 2 years, and for 1 year they must retain all electronic communication metadata related to that. And for a number of legal countries have been sued in a number of European countries, Cyprus, Germany, and other countries. And actually, the national courts of the national courts were really unable to do anything, actually. So human rights specialists had to turn to the European Commission and refer to the rights incorporated in the Charter of Human Rights, and they actually won the court case in April 2014. The EU Court of Justice said in its ruling that this law contravenes EU regulations. Hungary doesn't care about it. Attila Péter Vavi in Hungary wrote a letter about this to the minister. So the Hungarian law, the Hungarian jurists for democracy actually will start a case against Hungary in the EU to make the country stop the practice of retaining phone data and electronic communication data. Well, this was the summary of these cases I thought was very important. We can say in summary that data management based on appreciable grounds must be allowed in all countries. On the other hand, in these cases, sometimes enterprise interests are higher than individual interests, and thirdly, Hungarian law in part contravenes human rights charter. A couple of words about Hungarian legal proceedings. Here are 5 of them that were handled by civil courts, and I actually represented the case in these courts. In some cases I was successful, in some others I wasn't. The one about subsequent information, I won. I asked the pharmacy to inform me how what data they retain, how they retain it, and whether they have sent it on. And then I got the usual response, they didn't say anything, but I then sued them, and they were very, very surprised that somebody sued a pharmacy, and then they were forced to provide me the information. The next one is the public nature of research data. Medical research is a pretty special area of research, and an ethics committee must also review the research schedule. They are actually obliged to do so internationally, and this obligation also includes that they must publish the accepted, approved research plans or schedules on an internet site. Obviously, in Hungary, there is not a single web page in existence that would be used to publish such data. You never know, you don't know what they actually are researching. I had one website, I had one case where I sued a company in Szeged in my hometown and actually won the case. The next one is the public nature of data protection policy. I sued the healthcare organization because they did not publish these data. Now they do because I won the case. There were cases where I didn't win. One against the healthcare fund. In one case, the court said that I was not entitled to preliminary information, and the other one was about the deletion of healthcare data, for which I sued a hospital, and the court said that I was not entitled to having my healthcare data deleted. I just listed here Constitutional Court proceedings that I've actually lost, but there will also be one that I won. I filed a case against unwarranted workplace healthcare investigation. I also lost a case against unauthorized medical research. Data management. I said that the Hungarian healthcare service should not retain data for 15 minutes. The court said they can retain it for 50 minutes. 30 years data retention time for hospitals. The court said that this was totally okay. And also, I criticized the data content of recipes, and once again, I was rejected by the court of Constitutional Court. Well, they said that these data must be retained because people sometimes leave the recipes at the pharmacy, and this is how they can send it to them because they know their address. Retention time at the National Healthcare Service was initially not specified, and based on my motion and also due to Péter Falvi's motion in Hungarian Parliament, this retention time was set to 5 years initially, immediately increased to 10 in a couple of months, and now to 15 years. I also filed a case about unsubsidized healthcare medicine. It concerned the data content of the recipes. Once again, I won in the third round, and the National Healthcare Fund requested too many data for research purposes. I also fight against linking or connecting different healthcare databases together, among other things. All other aspects I lost, but the database connection was limited by the Constitutional Court. And in general, you can only turn to the Constitutional Court if you already have a final verdict by a judge, but if there is no option for legal remedy in the legislation, then you can turn directly to the Constitutional Court. And since data management has been made mandatory everywhere by law, therefore I can turn to the Constitutional Court without prior final verdict. And I actually demonstrated this as a first in this country, that this is possible. Another case that is currently in progress concerns Spanish Telecom. The one, it's one about paragraph F about rightful interest in data protection. In this conjunction, in conjunction with this, I said that this is the part of the law that should stand up them and they shouldn't mandate data management anytime when they want. Well, this case is in progress. I filed it at the beginning of 2012. It's still not decided upon. I also tried to attack paragraph 5 of the data protection law in Hungary, which states that data handling management is allowed after consent or based on higher interests. So, and I was actually my motion was not accepted. Thank you very much for your attention.